Okay. It is a little bit after 5 o'clock p.m. Central Standard Time. It is Wednesday, August 15th. Yay, I like the 15th in the last of the month. How many people understand why a lot of people like the 15th and last day of the month? It's payday. Yay. My wife is out somewhere, so I may have to interrupt the lecture to go and stop her from spending money. Okay, I may have to um, void her contract, not a voidable one. Oh God. Okay. Well, anyway, guys, welcome to week 2, and I'm going to spend some time going over the details of what's going on in class and discuss a few things. One of the first things I do want to discuss is that email that you saw that said something about WebEx lectures. Disregard that. The reason why is because, as you probably already know, I don't present the lectures to you guys in the form from WebEx. When you see them, they're on YouTube. So that means that I have not only downloaded them, but I've converted them for your convenience. I think you guys like the fact that it's on YouTube because you can use it on any device and that kind of thing. So you can find it pretty easily. So that's I started doing that a few years ago. So that's no big deal. So okay, so without further ado, I'm going to go ahead and let me make sure I hit the right button. My director quit on me. That's somebody who can say, hit this button. No, that's me. I still know. Okay. Let's lift you guys up. Oops. No, you guys are too big. I want to make you smaller. I don't want you to disappear. I don't want you to disappear either. Okay, anyway, that's fine. So anyway, here we are. I'm back on the home page again. All that information is up at the top, passing and scrolling down. I'm going to scroll all the way down where I passed something that I didn't want to pass. Go back, Richard. There we go. Put on the brakes. There we go. Okay, your written assignment for this week for your consideration. The 3 scenarios you have, and then it tells you to do each of those scenarios. You get 10 points for the first 2 if you do them right, 10 points for the second 2 if you do them right, and 5 points for the third, and then your APA citations with the cover page and the references. Now, be aware that when you write them, you can put a caption in there if you haven't already. It's okay. Scenario 1, and then write about it. Don't put it in list form, and don't give me short answers. Answer the question whether there's proper consideration. Yeah, there's proper consideration. Okay. Why is there a proper consideration, or why is there not a valid consideration? Explain it, provide some support for why it is, and then you'll get your points. Also, if you make sure that you have satisfied the requirements of the page, which I don't see here, but I will look, it usually says, okay, when we get down to the actual module, I'll do that. Okay, there's your discussion post rubric, which you guys are doing okay with. Live lectures will take place on Wednesdays, which is today, for the rest of this course. So we're week 2. So we'll have one next week, the 22nd. Yep, 22nd, and then the 29th. And then before you know, we'll be in September. And then the last one will be, let me think, it's got to be the 12th. Got to be the 12th of September because the quarter ends on the 14th. So you have to attend these lectures, and I appreciate it when you guys attend them live. I know a lot of you archive them, look at the archive, but it's nice that you come out. I appreciate that. Which I try to keep you just an hour. I may go sometimes a little over, but I'm going to try to not do that. There'll be a keyword given at the end, and you'll have to give me that keyword. At the bottom, as you can see, recordings. I recorded the lecture from last week, and I sent you an email giving you that link. I will do the same today with week 2 lecture, and then I'll have the link there as well. So that's how we'll roll this quarter here with that stuff. Let's get over here, and let's look at week 2 announcement. No, I want to do that first. Let's look at the calendar. Then we'll go to week 2 announcements. Here we go. And there we is. There we are. There we is. Wait a minute. There we are. My wife will say, "What school did you go to?" Okay. Anyway, here we are at the week of the 13th reading assignment. Again, if you click on these, it'll tell you the same thing. The chapters 4 and 5, which you'll hear me go over in a minute, of the book, and then read forming contract formation basics, and the flashcards are for training to help you. Those are cool. If you haven't done it, I'm going to show you how they work. They're awesome. There's about 3 of my classes that they put them in. Awesome. The voidable contracts, which was your initial post, was due yesterday by 11:59 p.m. Central Standard Time. I did remind you last week that your initial posts were not due on Saturday like the first week because we had a short week, and that on the regular initial post they'll be on Tuesdays throughout the whole course. And so it's about voidable contracts. I've seen some pretty cool ones, responses there. Our live lecture here, the reply post is due the 18th, which is Saturday. And then, the 18th, Saturday, and I won't be here, but I'll be checking you out still. I'm going to Dallas, Texas. So I'm going to be looking at my grades down there because I take my laptop. And so with my laptop, I have the laptop, and so I'll be grading your papers from there. And so, and if any of you ever try to reach me and you happen not to get me, like right now when I'm in a lecture, just leave me a message and then I'll call you back, okay, or text me. So, and so anyway, there's a written assignment. The written assignment is here again. I'll open it up. It's going to tell me to look at the module and the rubric. It is due on Sunday. So you want to make sure that you get that done. And then your course project, which we talked about last week, you're going to have your first course project, contract issues and worksheet, and we're going to talk about that in a minute. All right, so that's for the week. That's what your assignments are. You got your due dates. You got your times all calculated in here. So let's go back to the course home page, and let's look at the announcement. Again, this announcement at the top means nothing to you guys because of the fact that we won't be using WebEx. You have no reason to use it, at least not in this class, because of the fact that your lectures will be already sent to you and they will be uploaded on YouTube. So let's look at the second week. Contracts don't have to be scary. And whoever designed this course, and they don't have to be scary. And we're going to talk about that a little bit. Or you shouldn't even be worried about them too much. Okay, great. And so chapters 4 and 5 of Essentials of Business Law. Use your textbook, which you should be able to read and get that information. And then we're going to deal with contract formation basics and flashcards. So we're going to have a little fun going through that. Your initial post, again, voidable contracts due by midnight on yesterday. If you are getting them in midnight today, you are late. And then your reply post due Saturday. Okay. Alrighty. And finally, for your consideration, the written assignment and course project issues and worksheet. And I put in bold print. Can you see that bold print there? Highlighted the word pay close attention. You see that? All caps. I had a student one time said to me, and I sent them an email with something in there, all caps, and he said, to me that means you're yelling. I said, no, I'm 68. I'm not yelling. I'm actually putting that in there because I wanted to stand out. But somebody told me this. I said, well, okay, I'm sorry. That's not what Professor Wright does. Pay close attention to the rubrics. Repeating, pay close attention to the rubrics. And I should add, in all assignments. I have students all the time that come back to me and they say, Professor, I don't know what I did wrong. I says, in your rubric, when you see, and you guys haven't seen yet because you just completed your assignments on Sunday, and I'll be working on them to get them completed over the weekend so that they'll be posted no later than Sunday or Monday. But anyway, for week 1. And that's how it does. Usually you put them in on Sunday and you'll get them back that. I had a student that submitted them on Sunday, and Sunday night wanted to know had I had a chance to grade their paper. I laughed, but no, it doesn't work like that. I have 100-something students. So anyway, pay close attention to the rubric. For those of you who are, really say, I got it. I'm not doing that because of you. I'm doing it because of my experiences of trying to remind students that the rubrics. And the rubrics actually level the playing field because it tells you what I'm expecting you to do. Now, I also talk about your Grammarly. If your papers are higher than 25% on the Grammarly for plagiarism, which I actually discussed in the open house, then you want to make sure that you fix that because of the fact that I'm not even going to get to the rubric. You'll just lose whatever the percentage of Grammarly in there above that. So it's very important that you work on Grammarly because it reflects the fact that you have done your citations, your references. It also reflects the fact that you've given me critical thinking. That's what we want. We want your critical thinking. And I talked about critical thinking. In fact, on the right side of the home page is a nice critical thinking video because you want to look at that. And I also talked about critical thinking in the first week concerning our transferable skills and how important it is. And then finally, the last one is strong. Start strong, continue to be strong, and finish strong. I always believe in that. You'll learn my motto, and you already know. Adversity is a springboard to success. You know why? Because of what I shared with you about myself. I'm very, very open with my students. I consider my students as friends. I'm not the enemy. It's not this the professor, the nutty professor. I'm not that at all. I mean, listen, my wife says that sometimes, but if you got one of those, or if you got a husband, you know what I'm talking about. So, a little sense of humor there. Let's get to Module 2. All right. Got to take you through something already that I've been through because I still repeat them, but I want to show you how it works with the rubric. So here's your written assignment, all details. And it tells you, it says, each scenario should be a paragraph. Okay, a paragraph. Paragraph should consist of an average of 5 to 6 sentences, and include the source of your information, as I already said, and you're going to answer the questions that are listed here. Now, let me show you what your rubric looks like. So you click on this, and it will open up in a second. Two things. It'll tell you your due date. Professor, I didn't notice on the calendar the due date. I didn't notice on the announcements. If you try to do the assignment, the first thing you open up, you'll see the due date right there on the left side, and it's highlighted. Then it tells you points possible, which are 30. So there's no embedded rubric in this course, but the rubric is what we had on the right side there. And I emailed each of you. I hope each of you got them. If not, let me know. I don't know what would have happened if you didn't get them, but I did send you rubrics for the entire quarter. So there's your scenarios 1, 2, and 3. All right. Make sure you have a cover sheet, and make sure you have citations and, did you hear the conjunction, and references. I say that over and over again only because I promise you, if you were in my seat, you would see that person just put citations or no references, or references and no citations. Usually the common issue with APA is no citations in the body of the paper. And then your discussion about voidable contracts, which you guys did well. Wow, I think I'd hire you if I was still having an office for law clerks, because you all did some good jobs in dealing with these issues, among others that were not listed here. Some of you were very creative outside this list, and that's what we want you to do. Awesome, awesome. And then your course project issues worksheet. Okay, and that's actually on the home page to the rubric that I give you for this. Be sure that you follow all the details. Read the scenario carefully. As we say in the law, make sure. And, I couldn't find the worksheet. Here it is, right here, right in the middle, well, near the end. And you click on that. Just show you what it looks like. And it comes up as a Word document. Here it is. Let's make you guys a little. Let's see. I gotta move that up. Okay. Enable editing. That's something that I have here. And then, okay, so then that's my little note here. Okay, so then you can, this is it. And the chart tells you fill in the missing information and to answer the questions. And if you use that, you fill in your little boxy things there. You guys are familiar with how Word operates. So the fact of the matter is you want to make sure that you deal with all the information up here. And then what you're really doing, guys, is you're doing the first stages of writing a contract. And that's what we do in this course, is teach you how to write a contract. So that's a cool thing. when I was in school and we had business law, we didn't have that kind of thing, so it didn't work out so well. So we didn't learn how to do that. We read about it, but So I'm going to close down the Word doc there. Close that window. So we go back. So all your information here. So now, having presented that to you guys, do you have any questions about what your assignments are for this week? And if so, type in the chat box. And if not, type in the chat box no questions or whatever you want to say in there at this time. And I'll see it. Okay. Okay, to everyone, I'm looking, I don't see anything. No issues. Okay, nobody's typed in the chat box. You find your chat box? See, you all so used to speaking to me, but I muted your mic. So, okay, everything looks good. Okay, on my end, that's one person. Two more people that are with me here. Anything? Any questions? Okay, you just one student says just found the chat box. Okay, yeah, it has a little thingy that looks like a thought over the head in a cartoon, and then at least that's what it looks like on my end here. Um, so nothing. Okay, all right. I'm gonna go ahead and I'm gonna just presume that everybody's all good with that, and if not, then okay. Okay, good. I see another one. No questions for now. All right, excellent. That's the usually common response I get. Nothing yet. and then, and then later on, a student says, "Well, actually, something did come up, but you were in the flow." I said, "Don't. I'm in the flow. Don't stop. You know, give me, put your question in, and I'll stop. Just like if you're in class physically, that's the same way I want to roll with this as well. Okay, so now those are the assignments. Let's look at the lesson content so we can talk about what we have for the next half an hour or so. Okay, I'm still trying to find. Let's see, what can I do here? Okay. Okay, now I got it. Okay, everybody's still with me there. Okay. All right. So now, okay. Can you guys still see me? Can you see me now? I can see some of you. Okay. All right, I'm going to take that away for a minute. All right, you should still be able to see me. So anyway, our objectives for today: applying the basic principles of contract law, what a partnership is all about, agency relationships in business activity, define the elements to a contract, analyze assignments, delegation, and other commonly used contract clauses. And then we're going to talk about, I already mentioned this before, the Uniform Commercial Code, which you find that took over after in business law after the common law was removed. Common law consists of cases and decisions. There still are, but now there are interpretations of the common law. I mean, of the UCC. You heard me say UCC, it's Uniform Commercial Code, because I'm in the habit of saying that. So then, constructing a basic contract, we already kind of talked about that. So again, here's your assignments. Your reading assignment. We're gonna deal with contract formation basics in a minute. Flashcards. I already gave you your written assignment, your discussion post, your contract project, And then now here we are in the live lecture. Okay, so let's spend some time talking about contract uh, basics. Let's do that. Okay. First of all, contracts are essential, are very important to business. Contracts basically, for the most part, you should be aware of, give you an opportunity to communicate. You have an offer, you have an acceptance, or you'll have an offer, and then you'll have a offer, return offer, and then sometimes you'll have an acceptance, or then another offer made, and you go back and forth until you reach agreement. The bottom line is both minds, the party who is the offeror and the offeree. The offeror is the one who does it, the offeree is the one who receives, and they should connect. And so there should be consideration in the contract as well. We're going to get more in detail in that. Usually in most contracts, consideration is presented in the form of money. And so when it's presented in the form of money, it'll state in the contract what that dollar amount is. Let's say, for example, I'm going to sell you my car for $5. What kind of car I got? Well, that's no big deal. I actually sold one of my cars one time for $35, but it needed work, and anyway, I sold it to the person, and he fixed it up with the engine and all that, converted it. But offered it for $500, let's say, for example, and so the deal is that you say yes. So let's say let's put this in writing, and we might want to put that in writing because it's at the limit of the statute of frauds. You'll be learning about the statute of frauds. By the way, I will give you some information. I don't think I sent it to you. I might have. In the email that I sent you with information, did I provide you with any information that I got concerning statute of frauds? Anybody remember from last week? Did I do that? Did you get that email with that in it? I don't recall if I sent it or not. But anyway, I will check at the end here. Statute of frauds tells you the contracts. Oh, good. Okay, thank you. So I put in there a little mnemonic that I learned when I was taking the bar exam, which was 40 years ago, and I never forgot it. It's called My Legs, and it stands for, each letter stands for a concept of the statute of fraud, and I won't go over them right now. But anyway, M, just for one, is marriage. And so when you get all the way down to G, G is goods over $500. So that's why I was mentioning that when I mentioned the 500. But anyway, you'll see that there. But I do that because it helps you remember it. I ran into, I digress a lot here on this because I like to tell you little things that fit and get you a better understanding. Is I ran into the guy who ran the bar exam. He didn't run it. He ran the course preparing us, and he was the one that gave us this My Legs. And I said to him, I says, hey, I still remember My Legs. And, you know, if you weren't involved, you'd say, what are you talking about, My Legs? Anyway, that was an acronym for knowing the statute of frauds. And actually, when I interviewed for my job at Rasmussen in 2011, I used that in my little short presentation I had to do to show them that I did know how to teach. So anyway, that's a whole other thing. But My Legs is going to be important to you. And I had a first student that laughed when I said, My legs? Your legs are important to me? I said, no, I didn't say your legs. I said my legs. So anyway, so contracts are very, very, very important. And in order to be enforceable, uh, contracts, when you get to the statute of frauds, says certain contracts need to be in writing to be enforceable. To be enforceable. Now, that doesn't mean that you can't agree without a written contract for those things, but it's a dangerous practice. And then you'll hear me talk about, before this course is over, that there's what we call the Four Corners Doctrine. The Four Corners Doctrine means that within the four corners of the document, so I'm holding up my little pad here, and it has a top, it has a bottom, it has side here, each side. So anything that's within these four corners, it is in the contract somewhere. If it's outside it, we didn't put it in there, it violates the four corners rule. And it could be something that could create issues with the parties because of the fact that it wasn't on the document. Or as we used to say in just plain old English, if it's not in writing, it didn't happen. And it's not going to be able to be applied. However, the parties can always agree otherwise, and they can still continue it. But it's a good practice, guys. People come to me and came to me as a lawyer, said, I bought this thing here, and I said, do you have a contract? I mean, a basic. It's so basic. You'll know how to do contracts at the end of this course, and you probably already have an idea already. But the point of the matter is that you want to get into the habit, develop the habit of written contracts, because when you get into court and there's disagreement, how many of you seen something like People's Court or Judge Judy or what's his name out of Detroit, Judge Mathis? Those shows, you've seen those shows, and in those shows, one of the first things that the judge always asks, do you have it in writing? Do you have a document? And that's one of the things that is, because it's good evidence. Because guess what? The document can actually speak for itself. You don't have to explain everything. You might have to fill in some of the intentions if you leave them out. But anyway, that's the point. Get accustomed to putting in writing. So anyway, you want to make sure that you become a contracts person. And so it says here that a contract has to be based on mutual agreement. I already said that because the minds meet. That means that you agree. The most basic contract that actually is in the statute of frauds is one of marriage. You ask this person to marry you, usually, and most time it's the guy. I don't know. I teach my daughters, don't ask a guy to marry you. you let him ask you, and he better come ask me too. But anyway, the truth of the matter is you're going to ask, and then that person says yes, then it's not formulated until you actually get the license and go through, and the license are executed by a ceremony, whether it's with a judge or with a minister or however way. The bottom line, then, it is a contract, okay? So it was an offer and an acceptance, okay? And what's the consideration of that contract? The stuff we say, you are going to be honorable in this marriage. We don't believe in polygamy in this country, and you're going to be faithful to that person. Anyway, that's the most basic contract. So you have mutual agreement by the parties. And when you void that contract, generally, it's done by divorce. So that means then that you want to get out of the contract, and that's what that represents. And it's the same kind of thing. Almost, we say to people this: if you think of it like that, then you can think of it also in terms of business issues. And it says, I don't want this house anymore because of X, Y, Z that I discovered. I'll give you a tangible example. I bought a house, and I didn't buy it. I rented the house, and I had in the lease an option to buy the house. I had a price in there that I was going to buy the house for. I had an amount that we agreed upon in terms of the rent. I had a statement in there that certain amounts of the rent would be set aside to be applied towards the purchase, should I exercise that option. And then I had a given time. So in my case, I had 2 years. And so actually we extended the lease 1 year, extended the second year. So by the second year, near the end, I discovered mold in the house. And I said, I'm not buying this house. And so I didn't even really have to discover mold. I could have just said, no, I'm not exercising my lease. So I'm not exercising my option. So that means then that the relationship could end, or either I could become a straight tenant that's renting. And so that's how that works. Did you get that? You guys see how that basically works? You can shake your head. Al, did you get that? You got it? Okay. So all you guys, that's kind of like what we're dealing with here. I try to bring real life examples into our situations here. Both parties must be competent. Now, competency is an issue which we'll talk about in more detail, but just for introduction, be aware that one of the things is you must be of sound mind. Now, that means that you must be capable of understanding or comprehending what you're doing. And that has to do with the fact that you can't meet minds if you don't have good communication. Communication means you said it and the person heard you. And so now what we're talking about here is you must be competent. Some exceptions to being competent that are going to be dealt with more in detail are if you're a minor. If a minor goes out and they apply for a credit card, and they get that credit card, and they start using it and buying stuff, even if they forge, and it's discovered that, and then they come back to me trying to get the money from me, I say, oh no. And so now we got one of those voidable deals because we had some fraud in there, misrepresentation, all those kinds of things in there. But here's my whole point in a nutshell. That person who is under the age of 18 is not competent to execute a contract. The same thing applies to a person who's been determined to be mentally unstable and be declared that. Now, not that you think, yeah, they don't understand, Another thing, here we go again. Let's say, for example, if that person is not able to see and you're guiding their hand, and they're not competent to do that contract because they can't read it unless they have someone to read it for them. A contract has to be written in the language that the person understands. It is very common in the United States of America to see contracts that are written in the language of the parties that are involved, or the party. If I speak English and you speak Spanish or Polish, trust me, you could put a contract that's written in Polish in front of me, and I'm just going to be going like, I don't know. I just don't know. You put one in Spanish, I can kind of say, se habla poquito en español. Okay, which means I comprehend or speak a little Spanish. And I know, I understand it. But the point of the matter is that I'm not competent to do that. When you execute contracts, it should be able to be understood by you where you are at that particular time. If you are drunk at the time, drugged, the bottom line is the person has to have the mental capacity. That's where we get into that, and that's where we get into competency. Number 3, the promise made by each party must be supported by consideration. As I said before, consideration is commonly money amounts. However, consideration can be performing a service. You can agree to, for example, I could sell you my car if you decide that you're going to paint my house, and you paint my house. and I'll have to describe what that means to make it specific. Painting this room, this room, this room, this room, this room, those kind of things. So there are services that can be there. But usually we see these phrases, good and valuable consideration. Have you ever seen a real estate document called a deed, whether it's a quitclaim deed or warranty deed? It usually says the consideration is, might say $1. You bought a piece of property. It says $1, but what it does say after that, it says $1 and other and further valuable consideration. And generally what that means is that there's some other amount that either takes place or some service tied to it. So there are some other terms that if there's invalid consideration, again, we'll get into that a little later, just as for basic to get you started here. It must be lawful. Hey, man, look, I'm going to make this deal with you. All right, here's the deal. I got this crack here. I want you to go sell it, and I'll pay you $10 if you sell it. And then so then you sell it, then you come back to me with the money, and I say, adios. See you later, dude. I'm done. So wait a minute, we have a contract. Okay, and even if you put in writing, you're going to take that to court? Well, we get into the criminal law side now. And says no, because you take that to court and you says, Judge, he didn't pay me. We're both drug dealers. I'm supposed to get paid for this. Judge says, yeah, sure, your contract's valid and all of that. Bailiff, take them into custody, and then you're in jail because it's an unlawful contract. It is not legal to do that, okay? And so anything that's unlawful. Let's say, for example, okay, now here's the deal. I am a lawyer. I'm retired. I don't practice anymore. I surrendered my license years ago, but I still study and get the knowledge. The only reason I surrendered is because I wanted to do something else, ministry. And then somebody came back to me and brought me back into teaching this stuff, which is fine. I can still teach it. But what I cannot do is you come to me and say, I'm going to pay you to do this contract. That's illegal. I can't do that. I can't unless I go and activate my license, which I can, but I'm not interested in that. The point of the matter is then I'm technically not attorney anymore, even though I am attorney, because it's based on a license. Do you have your license to practice law? No, I don't want it anymore. I'm done with that. But the information, I'm well qualified. I have a law degree, and I still consider myself an ability to be able to share with you because I study what I already know. So the knowledge didn't go away. When I surrendered my law license to practice, I didn't surrender the ability to be able to teach and to tell people without any money what that is. So same thing, you hear people talking about practicing medicine without a license or doing this without a license. If you're an accountant and you call yourself a CPA, then you should have a license, but you can still be an accountant. So anyway, I've given you one with the drugs. I've given you that. But it has to be for a lawful purpose, okay, in order to be a contract. In some cases, I already told you, it must be in writing. And so I'm going to defer that for right now. So we already talked about that. So at this point, I've covered some very basic things that you already know now about the 5 elements. All right. So, and then it says check out an article, which I'm not going to do that, but you know what I'm talking about. Offer and acceptance. So now we did that too. If a contract is going to take place, as I already said, I use that phrase, meeting of the mind. That's an old term that we've been using forever and ever. And so, as I said, the parties have to be able to be on the same page. That's the best way to say it. You got to be on the same page. That's when you get the offer and the acceptance. All right. It must be definite. The offer must be definite enough. I'm going to sell you my car. Um, I might sell you my car. And you say, okay. Did we make a contract? Did we enter into a contract? No, we did not, because there's nothing definite about it. One day, I'm going to give you, uh, this pen right here. You know, I'm going to give you it one day, and I don't give it to you, and then you're waiting and waiting, and then you get tired of waiting, so you're going to take me to court for the pen. Well, first of all, number one, your lawsuit will cost more than the pen. You could probably go get your pen. But anyway, the point of the matter is this. It must be definite. So you got that concept. It must appear to be intended seriously. You listen to me. You don't need Attorney Wright or Attorney Jones or Attorney Smith or Attorney Johnson to tell you, that part. You know that already. You understand, okay? If I stand on stage and I say, I'm buying everybody in this room a drink, and there's 200 people in the room, and those people, they'll laugh, ha 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 ha, and I don't buy them a drink. Well, then they're gonna say we offered and I accepted. I said, no, man, I was kidding. Come on, And so the point of the matter is, it has to be seriously intended. It must be communicated to the offeree. Okay, here we go. I'm going to say this. I'm going to say I'm making a contract with Al. All right, I'm going to make a contract with you, Al. But then I don't go talk to you. I go and I talk to Janet, and I say, Janet, such and such a thing that we're going to do. And Al, you'll be sitting there saying, oh, wait. You're supposed to be making the deal with me, but you're talking to Janet. Well, I'm making anybody the offer I want to. No, there's only one of those or a group of those in a situation. You have to be focused on who it is you're dealing with. Does that make sense to anybody in this? Does it make sense? Contracts pretty much are using your common sense and intelligence that all of you guys have, that you can put on a robe and you can go to a bench and you can pretend you're a judge. But don't do that in a real court. You can go to jail for that. But and you can actually say, I know this already. I learned this in week 2. Professor Wright told me. And so anyway, the bottom line is that you have all the abilities and capabilities to do 1, 2, and 3. And you already did that before you came to business law. So why am I taking business law? Because that's just the surface, okay? There are more details. And so then we're not going to get to this e-confidence offer and acceptance in online contracting. You can look at that on your own. And so I want to talk about, again, before I move down, the capacity. You must possess the capacity to contract. We talked about that. It says, and I'll repeat it again, there are some persons that are not allowed to enter into contracts because of their age, their intoxication, mental capacity, or are they a convicted felon. Now, listen to me. You listen to me good. You said, I saw that. I said, let me explain that to you. That's old stuff. It doesn't, in each jurisdiction is different. Usually in most jurisdictions, if a person, they attempt to say that because they're a convicted felon, they can't enter into a contract, that means they can't operate and exist. They could go to court and it'll take it all the way to the Supreme Court, and they'd come back and say, that's a basic right. You can't do that. So anyway, don't get hung up on that last one. But the main ones are the first 3 that I mentioned: age, intoxication, mental capacity. Those are, can you get too old to execute a contract? Yes, but it's not based on your age, actually. It's based on your mental capacity that may leave. I know some 90-year-olds that mental capacity was sharper than some 20-year-olds and 21-year-olds and 22-year-olds and 23-year-olds, you know. So, I mean, I'm 68. I got an 18-year-old daughter at home and a 19-year-old son here. I got a 23-year-old son, and I got a 10-year-old daughter. But I'll use the first three, for example. They're competent. The first three are competent to enter into contracts. Hey, my son said, Dad, would you sign for me a car? I said, no. I'll help you to get the money for it and then help, you get your financing, because I already told you what to do. I said, do like I did. I got a car I paid cash for, and then I drove it. I did my little fix-up stuff on it, and then I got to the point where I could sign for me a car. Because you know what happens? We'll talk about this later. You all are all well-versed in co-signing. If there's anybody in this group that doesn't know anything about co-signing at all, we're going to talk about in detail later. Raise your hand or let me know or tell me. I never heard of co-signing. I don't even know what that's all about. You don't even have to go to school for that, because you heard that early on. Because you'll go to get something and somebody says, you got to have a co-signer. Okay, it means what it says, co and a signer, somebody to sign with you. And their credit is even as good, or something, maybe your credit is not good, or, I want to buy this car. Okay, give me your employment history. I live at home with my mom and dad. Okay, but do you work? At home, I clean the car. I take out the garbage. I get a little amount of money from my mom and dad. But no, the person's gonna say you need a cosigner. Ask mom and dad if they'd cosign. So anyway, that's the whole point in a nutshell. So the capacity issue is very important. Okay, entertainment contracts with minors in Texas. I'm not going to get into that. Like I told you, I'm going to Texas, but I'm not getting involved with that kind of stuff. But anyway, you read that on your own. An additional requirement is, as I already talked about, consideration. The courts separate legally binding obligations from mere agreements by checking to determine there's adequate consideration. And that the price, which a promisor, which is the offeror, remember if it's an or, it's the person that is doing it, or the is the person that's presenting it. If it's the E, it's the person that receives it. The example that you should be aware of already is you have an employer, that's your boss, and then you are the employee because you're the recipient, okay? And then you have consideration that goes with that, like this thing that happened I told you today, the 15th, is a good thing for me. I like Rasmussen College. I love it. But they have to pay me. I like you guys. I like hanging out with you, too. I like talking to you and sharing with you. But I need money, okay? Since I speak my Spanish, I always like to say mucho dinero. Okay. So anyway, the point of the matter is that your consideration requires a promise. Okay, promise to pay net. So that is actually the whole issue about contracts, and that's why I said, don't be scary. It's not scary. It's actually good, and it keeps you focused. So I'm not going to get into much detail as we will. I'm giving this a little at a time because I had an instructor when I had business law way back in 1969, before you guys were born, okay? And my instructor, keep in mind this. I worked in a law firm and starting in the mailroom, and I told you all about that. And I'd go to school at night. I had these two crumb snatchers at home that are 47 and 46 now, and now they got their crumb snatchers that are my grandkids. But here's what I'm telling you. This guy would, after being working all day, and I'd get into class 4:30, and I'm there until it depends on for maybe an hour or 2 hours. This guy would try to throw 3 and 4 uh, chapters at us in the one lecture, and expect us to be able to. And so we're sitting there looking like we're tired. We are, but anyway, the bottom line is overload. It doesn't matter if I give you the information if you don't understand it and you can't apply it. So my goal, good people, is at the end of 6 weeks, 5.5 weeks, that you be able to say, Professor Wright helped me to fill in the blanks that I did not already understand about business law and the contracts. And that's my deal, okay? And that's my offer to you, and you accept it by staying in this class. And if you don't accept it, you're going to get a 0 if you stay in the class. So it's not an offer you can't refuse. It's not one of those kind of deals, but you got it. Okay. All right. Every student that has had me in more than one course will say, "Is Professor Wright doesn't give you like, here we are on page 4. You will find such and such a thing. So now turn to page 6. On page 6, you will see this, and read the following from page 6. Now I'm going to read from page 7. Thank you guys for coming out today." What? I could have done it on my own. No, I'm going to give you stuff like what I did here. Okay, I want to engage you, and then I want to make sure that you're getting it. All right. So now, having done that, let me close this down here for just a minute here. Let's go and okay, let's put that back, and then let's put this. Let's move that down a little bit. Okay. So now, the following activity, these are things I want you to do on your own, but I'm going to show you how important they are. Using the following activity, you're going to learn concepts and terms. And that's one of the key things about the 3-letter word LAW. It's rules and concepts. When I say an offer, you say, "Oh, yeah, I know what that means." When I say an acceptance, you know what that means. When I say consideration, you know the definition of what that is. And if you don't know now, you're getting ready to find out in a minute. Okay, so anyway, okay, here's a flashcard here. Okay, so you know already. So you go back. But here, let's go back. I like to do this differently. When I'm looking at this by myself, I do it one way. Okay, contract, and then you autoplay. That means you're on speed. You don't want to do that, okay, because it's going to be going fast. Okay, so you take it off of that. But let's go back. I want to go back for just a minute here. This is how I go back. This is the best way I know how to go back. And I want to show you how you can do it in your own time. Let's go back to lesson content. Here we go. And we're just about done, so just hold on there. Okay, let's get down here. Now, what you can do, and I showed you all this week. Al, you were with me, so you know you can hit speak, right? And if you hit speak, acceptance, then it's gonna, if you flip it over, it's gonna tell you. Thank you, Miss Lady, and she's told you the answer. So now you know the offeree's manifestation because of assent. So you have an agreement there. Okay, so then you go to the next card then. All right. Okay, so what's a bilateral contract? So then it tells you what it is. And you learn that. And you know what? I'm going to tell you something. Do you not know that if you read it and hear it at the same time, it will soak in better than if you just read it without hearing it? That's why you got these things on your these two things here. Okay, on these two things here, so that you can get it. I always tell people, and because I'm a pastor also at church, I says take out your Bibles. And so sometimes people don't take out their Bibles, and then I say a passage from the Bible, and then if they are reading along with me and they're hearing me, it'll get into them faster, and they'll have a better understanding. And so that's the same thing I'm saying here, okay? And then so we go with the next card. Okay, you should be saying, "Oh, I already know that one." Yeah, but listen to it. Mhm. So there we go. And when you take tests and quizzes, you're going to see, oh yeah, that's what that means. I remember. And then you're going to remember that you heard and saw it at the same time. I'm not doing all of them. Express contract. Oh, I know what that is. That means it's going to be a fast contract. No, it doesn't mean that. Watch this. Because you think about express. Ooh, you get on the expressway. No, it means what it says. Okay. So generally the rule is that when you are defining something, you don't use the word in it. But this has to happen in this because in express language to make it clear. Anyway, you get an understanding about what we're talking about here. I skipped over because I didn't go. So then flip it over. So then you don't have the essence of what it takes to have the minds meet. You follow what I'm saying? Remember, see, look at this. Remember I said the promisor, the person who made the promise. The promisee is the person who receives it. Okay? You don't see that in there, but remember I said, remember the or, the e, or the or-e rule. Usually the e is the second party. Okay? Implied contract. Okay? So you keep going, and you go through these cards. This is a cool one here. Um, Anybody have an idea about what that mailbox rule might be? If you don't, just shake your head. I'll tell you. I'm gonna let my lady tell you here. But it is. It has to do with that, and you'll see. It makes sense after you hear this. Okay. And so the mailbox rule says that you can accept an offer by mail. Now, let me ask you a question that you should really know. You will know is that if you accept an offer by mail, uh, how do I know that how do I know when you actually accepted it as far as if it's by mail? What's one bit of proof that you can present or you should be aware of that demonstrates an offer? If I was going to send an offer by mail to somebody, then signature proof. That's good. You're on the right track. But there's one that's even more simple than that. By signing and receiving, okay, that's the person who is who actually has okay that. But it states as long as the proper way to accept an offer, you're both right. But here's what I want you to know. It's easier than that. Do you ever get mail and you look at the mail? I mean, at least most of it. Now it's not. Now it's going away. But I guess I'm dating myself by saying this. You don't see it a lot. Like, for example, I got something in the mail. I'm holding in my hand. I'm not going to show it to you because it's got who my creditor is. You know, actually, no, it's not my creditor. It's my life insurance. And if they mailed me something, and they used to have a PO, a postmark. You know that? You know what I'm talking about? It would be a mark that the post office would put on it. That postmark would tell you actually the date that it's considered as accepted. So how do you get the postmark on there right away? Put in a mailbox, or how do you get it postmarked right away? How do you get it postmarked right away? Sure, you all have done this. You might not even thought about it, but you've done it. How do you do it? What do you do? Okay, but what do you do if the simplest way of getting your postmark on it, go someplace. I just tipped you now. I gave you a clue. Where do you go? I'm talking about regular mail, by the way, now. Or I'm talking about mail, not shipping like UPS or those. Yep. Well, you don't have to get the stamps, but yeah, because they'll want you to buy stamps. Al, you need some stamps? No, thank you. I got a whole bunch of them. You know. Oh, by the way, since I'm digressing, you brought stamps up. Um, get the stamps that last. You know um, you know what I'm saying? I forgot what they call them, but anyway, get those because rates go up. They still got to ship your stuff using stamps. So I got a whole man. I got a whole. If they ever pass a law barring them, I'm gonna have to find a market to sell them. But I got a whole bunch of them, you know. So feel free to ask me, say, Professor Wright, could you mail me a stamp? I live in Minnesota, but could you mail me a stamp? I said, did you hear what you just said? You want me to mail? Yeah, I'm going to mail you a stamp, but it's going to have, it's going to be postmarked. When you get it, that means it's no good when you get it. Anyway, yeah, seriously though, that's a simple way. See, you know what, guys? There's a lot of things that people have right in front of them. They're doing them. They're not even thinking about it. But if you take it to the counter and you give it to them, you'll see that clerk right then and there. They'll take that little postmark thing out and put the stamp on it and throw it in the little thing, right? That stays on it in that. So, you know what you can ask to do? It says, can I get you a document telling me that you postmark it? Yeah, I did that several times without paying extra to have the IRS send in special mail. I said, could you give me a document showing that I delivered this to you on this date? And they gave it to me. So if the IRS says it's the 16th, I said, no, I did it on the 15th, and you have this document as proof. So anyway, you got what I'm saying there? Okay. So anyway, that's just a little side thing. Okay, and those are the things I want you to do. That is our lecture for today. And so, any questions? Yep, it's like proof of date, exactly. Any questions other than what I'm going to give you in a minute? Any clarification on anything? Everybody's all good? Okay. You can tell I have fun doing this. I love what I do. I have a whole lot of fun. See, so now when you I was going to tell you this is an aside now since I saw you do it, Al. You got up out of your chair and you sat back down. So let me tell you a little funny story. That's why a lot of times people will do something like this. They will do this. Uh, okay, I just stopped my camera. You can still hear me, but you can't see me. So we have people that do that. But anyway, I'll start it back. But anyway, what I was going to say, and then you see my little picture in the circle that is in its place, is because we had we use these same systems for meetings, and we had big faculty meetings from all over the country, and this guy forgot that he was in his underwear, and he got up. And when he got up, everybody says, "Oh," and then he didn't think about it, but it was on tape. And he got up. Anyway, the bottom line is this, is that when it's on tape, it's just like I teach criminal justice. I tell people, that's why we tell police officers, do what you got to do right, because you're being videotaped. Smile, you're on candid camera. And you see. So anyway, I'm going to let you go. It's 6:15. Contracts. That's it. That's the word, contracts. Now, I know a student's going to come back and tell me, you never said what the key word was. Everybody who's listened to me knows what the key word is now, right? Isn't that right, Al? You know what it is, right? Okay. And Deandra, you know what it is. Janet, you know as well. So other people will know when they see the archive. So I'm going to say good night to you. Again, if you have any questions or concerns, reach out to me, and I'll be happy to accommodate you. I'm going to say, I usually say good night, but good afternoon. I'm getting ready to go do my 2-hour workout. I do that in the evening. So then I'll come back and take a shower, grade papers, and give people good news, like you did well. Have a good evening, afternoon. Bye.